Hello, everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're very excited to host this FedSoc forum called An Environmental Law Revolution. Will DOGE and the second Trump administration achieve lasting positive change? This webinar is the fourth and final installment of our Theories of Presidential Power webinar series, which has been a preview of our upcoming 13th Annual Executive Branch Review Conference. Speaking with us today, we're very pleased to have Eric Grant, Matt Leopold, Professor Andrew Mergen, and Sam Sankar. And we're very thankful to Jeff Wood for moderating this program today. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Near the end of the program, we may turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. And finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. With that, Jeff, thanks so much for joining us today, and I'll hand things over to you.
Thanks, Edie, and thanks everyone for joining us here today for this last of four webinars previewing the Federalist Society's 13th Annual Executive Branch Review Conference on the topic of theories of presidential power. I serve as the chair of the Federalist Society's Executive Committee for the Environmental and Property Rights Practice Group. Our executive committee is comprised of environmental and property rights lawyers around the country. We hold events monthly, sometimes several each month, and produce publications on a wide range of environmental and property rights topics. Our main mission is to host robust debates between leading scholars and practitioners from diverse viewpoints, and today is no exception. Our executive committee is honored to plan this afternoon's panel discussion entitled An Environmental Law Revolution: Will DOGE and the second Trump administration achieve lasting positive change? Since Inauguration Day, President Trump and his cabinet have taken a range of important executive actions directly impacting environmental law and regulations, with a laser focus on achieving domestic energy dominance, a centerpiece of the Trump-Vance agenda. Many of these actions are highly controversial and headed for legal battles in the courts. In the current edition of National Review, legal commentator Dan McLaughlin has an article titled "The DOGE Ate My Constitution," where he applauds the objectives of the Department of Government Efficiency, including, quote, cutting government bloat, exposing wasteful spending, and drastically restructuring many federal agencies and programs, end quote. But he also cautions that, quote, even the most urgent of causes needs to be pursued within the law. And he writes, failing to follow the law makes it far less likely that beneficial reforms will be implemented, end quote. This observation is particularly relevant in the environmental law context, with its labyrinth of overlapping and complex statutory and regulatory regimes, and armies of federal employees and contractors. The panel today will review the new administration's long list of executive actions and major reforms and their possible future impacts on the environmental law regime, with a focus on whether these developments are, in fact, revolutionary, whether they will last or be a flash in the pan, and whether they are for the greater good or for ill. I'm here today as your moderator, and I'm joined, as Edie said, by four distinguished attorneys with deep experience in environmental law. First, Professor Andrew Mergen, a visiting assistant clinical professor of law and faculty director for the Emmett Environmental Law and Policy Clinic at Harvard Law School. Professor Mergen previously served in the appellate section and as chief of the appellate section at the Justice Department's Environment and Natural Resources Division, or ENRD. Next, Matt Leopold is a partner in the Washington, D.C. office of Hunton Andrews Kurth. Matt served as EPA's general counsel during the first Trump administration, and he also previously served as general counsel for the Florida DEP and is a former environmental litigator at DOJ ENRD himself. Third, Sam Sankar is Earthjustice's Senior Vice President for Programs. Sam also served at the Justice Department's Environment Division and as a senior executive at GE and as Deputy Chief Counsel of the Presidential Commission formed to investigate the 2010 Deepwater Horizon oil spill. He clerked for Justice Sandra Day O'Connor. Last but not least, Eric Grant is a partner at the law firm of Hicks Thomas. Now based in Sacramento, Eric previously served during all 4 years of the first Trump administration as the Deputy Assistant Attorney General at DOJ's ENRD, where he had involvement in virtually every significant appeal involving major actions in that time frame, including many involving significant energy-related topics like the Atlantic Coast Pipeline, Keystone XL, and the Juliana Kids climate litigation. Eric clerked for Justice Clarence Thomas. We'll begin with brief 3 to 5 minute opening remarks by each panelist. I'll then give an opportunity for brief rebuttal remarks, if any. And then we'll turn to a discussion focusing on federalism principles, the Supreme Court, DOGE's efforts, and among other things. We'll also try to save time for questions from the audience. So with that, Professor Mergen, let's start with you. Then we'll hear from Matt, followed by Sam, and then Eric will back clean up. Professor Mergen.
Great. Thank you so much, Jeff, and thanks to the Federalist Society for having me. I think I'm here as a member of the left side of the aisle, and I appreciate the Society's commitment to diverse opinion and robust debate. I worked for both Jeff and Eric in the Trump administration and the first Trump presidency. And at DOJ, we have a saying, bluff, bottom line up front. So I'll start with my bluff. When Jeff and Eric were my bosses, I recognized that their time was short and I needed to cut to the chase. And I don't think that where the Trump presidency is heading at all in the right direction. I do not think these changes are positive, nor do I think that they'll be long lasting. I want to focus my remarks on one aspect of what we've seen so far in the Trump presidency in the second term, and that relates primarily to the civil service. But I want to frame it up briefly too, which is that I was very privileged to work at the Justice Department for a very long time, and now I'm very privileged to work with really tremendous law students from around the country. I work at a large law school that attracts a diverse student body, and I often have conservative students come to me they're often from Texas or California Central Valley or the Upper Midwest, and they say, "I'm very concerned about climate change. I've seen it. I know that it's real. I'm very concerned about the environment. I grew up hunting or fishing, and I'm wondering, is there a space for me in the conservative world? Because I am a conservative. I believe in limited government. I'm not a fan of the administrative state, but I hold certain environmental values very dear and very important to me. And I love talking to those students. And one of the things I usually told them was that one great place to explore your interest in environmental law, and I think is in the federal government, to see how the federal government works. It's also a really great place to develop skills. And you don't have to be there forever. And one thing that all of us on this panel have in common is that we all served in the federal government. And I think 4 out of the 5 of us served in the federal government as career civil servants at one point. So that's a commonality. And of course, the reason that people go to DOJ is to acquire skills. What I find particular, so that is historically what I've told some of my conservative students: go see what it's like. And I guarantee you'll pick up some skills along the way that you can deploy in a very successful lawyer career down the line. I'm really at a point where I'm having trouble making that recommendation because of the incredible damage I think this DOGE operation has done to the civil service. And it strikes me as Jeff alluded to earlier, both unlawful, but also just dumb and cruel, and also counterproductive to the stated goals of the Trump administration. What we have seen is really a wholesale gutting of the federal workforce, starting with the fork in the road offer and continuing down to various rifts. And it's done with a hatchet, not with a scalpel. I would agree that there's been bloat in the federal government for a long time. I think that there's real cause for civil service reform. But what we are losing in this DOGE operation is tons of agency expertise that is very, very important to surviving in the modern world, whether that's environmental expertise or national security expertise, or just delivering services to our veterans and the like. And this is really damaging to the project of governance and environmental law across the board, including counter to the Trump administration's stated goals of bringing more aggressive management to our national forests, or developing mineral resources, or all of that depends on a cadre of professional civil servants. And those people are walking out the door, and it's going to take a long time to get that expertise back. I'll just close by saying, I think this is really, really damaging. I think people really need to pay attention to it. It's not at all surprising to me that writers in the National Review are sort of saying too much, too fast. wrong-headed. And I'm going to close with one thing that I think I've always enjoyed talking to my colleagues on the right. I think that there's a lot of things that we can agree on. And one thing that we should start thinking about now is legislation focused on civil service reform to rebuild when this episode is over, because we're seeing a brain drain. We're going to need to bring people back. We shouldn't reconstitute the civil service as it was, but we're going to need people. We're going to need young people. We're going to need smart people. And we should start thinking about that project immediately. And that is a project I think that should be attractive to people on both sides of the aisles. And I'll stop talking. Thanks.
Yeah, thanks, Professor. Matt, how about you for your opening remarks?
Thank you, Jeff, and thanks for the opportunity to be here. Let me try to just you've heard a little bit about what the DOGE is doing and what this administration's effort is more broadly. So I was going to just try to hit some of the key things that are animating the administration, what's been done so far. I think we can clearly say this is the largest attempt in multiple generations to reform the administrative state. The president has clearly focused on energy and environment as part of his first 100 days. The administration has linked American prosperity to a thriving energy industry domestically. And that is the focus of much of the deregulatory approach. It's also, critical to allow, environmental regulation and permitting that allow continued growth in the energy industry as well. And by contrast, I think the last administration had a strategy of tightening environmental regulations to eliminate the production, transportation, and combustion of fossil fuels. I mean, that was pretty openly stated. So DOGE and the effort to downsize the federal government, I think, is an attempt to get at some of those issues. And that's the size of government, the huge growth of regulations over the decades, and as the administration has stated, fraud, waste, and abuse in programs. And I think we all could potentially agree that Congress has failed to make any meaningful change in the growth of government. And so this administration is trying to take every tool available to the executive branch to shift that direction. As Professor Mergen mentioned, one of those is reducing the size of the federal workforce. And the president issued an order on workforce optimization. That includes a 5-day return to work order that, after COVID, many of the federal agencies were empty because folks were working from home. And so that policy has been reversed, as well as the buyout for federal employees who want to retire and resign at the end of the fiscal year. And we've seen OPM, which is usually a very sleepy agency in the federal government, be energized and empowered to do a lot of these things. I think the second thing that DOGE is focused on is an attempt to root out wasteful spending. According to their website, which I checked today, it says, they have this effort will save $160 billion thus far through a combination of sales, renegotiations, improper payments, grant cancellations, and other measures. For this audience, EPA and the Department of Interior were listed as 8th and 11th, respectively, for federal agencies where the most savings have been identified. I think the third thing I would note about the DOGE efforts is the effort to reduce the size of the federal bureaucracy. And so that means that this order, which was also issued in February, would reorganize a number of agencies, including EPA, where the Environmental Justice Office has been shut down. There's talk of eliminating or reducing the size of the Office of Research and Development, as well as was alluded to, similar changes at the Environment and Natural Resources Division, and likely more of those efforts to come based on work that is ongoing. But perhaps the final thing and most important, perhaps for this conversation, is the president's executive order on ensuring lawful governance and implementing the deregulatory initiative that was issued on February 19th. And so that order directs agencies to review and potentially rescind regulations that are not in the national interest based on exceeding the scope of power in federal agencies under the Constitution, unlawful delegations, major questions consistent with West Virginia v. EPA, anything reading statutes or regs anyway other than the best reading of the law, consistent with the Loper-Bright decision. Also, I think key to this effort is questioning those regulations where costs outweigh the benefits. And also, the administration's also noted that enforcement actions should be curtailed where they violate any of those principles. We've seen quick action by EPA on this. On March 12th, the administrator announced 31 deregulatory actions along a host of lines, but a theme running throughout was energy and deregulation in that space. And so maybe in some, and I'd like to discuss more, the president's efforts and this administration's efforts are trying to build upon what I see as an ongoing project by the Roberts Court to really rein in the administrative state. And we've seen a number of key precedents in recent years that this administration is pointing to, such as Loper-Bright, West Virginia v. EPA, Jarkissi, Michigan v. EPA, and others. And so I think leaning on that, the administration has a new opportunity to rescind regulations and also challenges, I think, in implementing those decisions. But I'll leave it there for now.
Okay. Yeah, thanks, Matt, so much for that. Sam, what's your perspective here at the opening?
Well, I think everybody here, first of all, being identified as a member of the left is always sort of entertaining for me. I'm a former corporate executive, Justice Department person, clerked for a Republican Supreme Court justice. I was pushed into this category of being on the left by the first Trump administration, and I'm finding myself very comfortable. If I have to be declared as the left in this Trump administration, I wear it as a badge of honor. Again, I work, for those of you who aren't familiar with Earth Justice, we're the country's largest environmental law firm, about 220 lawyers here. And we're run, as by a lot of former Justice Department folks. And from our perspective, the question presented in this talk was, will DOGE and the second Trump administration achieve lasting positive change? Well, positive? No, basically nothing that's going on is positive in any way, shape, or form, even if you believe in the policy agenda of the Trump administration. In fact, I would argue there is no policy agenda of the Trump administration. It's mostly a policy of retribution and a religion of deregulation without any actual policy aim. So the most obvious way this plays out is in the energy world. President Trump on day one announced an energy emergency in which he said we need a reliable, diversified, and affordable supply of energy to drive all of our business. Caused by the harmful and short-sighted policies of the previous administration, we have inadequate energy supply and infrastructure. It's driving high prices and so on, which is frankly just ridiculous. The prior administration supervised a expansion of oil and gas production so that the United States is one of the largest fossil producing nations in history. Oil and gas are at record levels of production in this nation. The reason the Biden administration was trying to rein that in is because of the collateral effects of this fossil-based energy economy. There was a policy aim to what was going on. By contrast, the Trump administration has pursued energy dominance, but then specifically excluded renewable energy from that for no conceivable reason aside from a sort of desire to throw a middle finger at environmentalists and to just be sort of scoring political points. So, and if you think I'm overstating it, here's the definition of the term energy, which I'd invite any of the panelists here to explain to me. Energy or energy resources means, quote, crude oil, natural gas, least condensates, that's gas, natural gas liquids, more gas, refined petroleum products, uranium, coal, biofuels, geothermal heat, the kinetic movement of flowing water, carefully constructed term, and critical minerals. Critical minerals are energy. Why are critical minerals energy? Good question, because nowhere in here is solar, geothermal, or wind mentioned. It is an actual vendetta without any policy basis against the renewable energy industry, motivated purely by a religion of anti-climate change, against climate change. And it's destructive to the US economy because renewable energy is cheaper. And by banning it, essentially, the administration's causing tremendous damage. Ditto on the vehicles front, the administration is pushing a anti-EV policy that's going to destroy American automotive competitiveness by essentially creating a fake little greenhouse bubble for the American auto industry to compete in nationally that won't allow it to compete more broadly. I could go into a ton of health principles or health problems as well, but so that's the positive part. On the lasting part, so much of what the administration is doing is just, I mean, frankly, we're salivating over here. I can't wait for them to actually do any of these things. I predicted before this administration that we would not match our same 85% win rate in the last administration in front of tougher courts. Now I think it's going to be better because the administration has fired everybody who could really do a decent job of advising or defending these, as exemplified by Sean Donahue, the nominee to be Matt Leopold's successor as general counsel, a person who has an almost laughable legal track record. If this is the guy who's meant to superintend EPA's promulgation of lawful regulations, bring it on. And then the last thing that I think is important to mention is that the Federalist Society is committed to open debate, and yet every member of the left in this group here is under attack from the administration. Professor Mergen works at Harvard, an institution where the administration has targeted, just explicitly and nastily targeted, for removal of its C3 status. That jeopardizes Mr. Mergen's job and his ability to continue pursuing his work. Similarly, there are strong rumors, strong enough that we've had to retain counsel, that the administration will be pursuing environmental groups that pursue change related to climate. They've also done this with respect to law firms. Perkins Coie, Jenner & Block, Wilmer Hale have all been targeted. Every member of the Federalist Society should be looking at this and recognizing that any debate we have about any issue falls under the shadow of the administration's attack on the rule of law. We stood up for those law firms. They are adverse to us in numerous claims. They are not our allies. We stood up for them because we believe in the rule of law. We believe in the need to protect lawyers advocating positions. I have to point out that on this call, none of the law firms represented by these three people did so. And I view that as really problematic, and I encourage members of the Federalist Society, everybody in this call, to ask each other what you have done to stand up for the rule of law. And if there's nothing you can say, then I wonder what it means to be a member of the Federalist Society.
Okay. Thank you, Sam. Eric, that was a charged set of opening remarks. What do you think? What's your take on the current topic here?
Well, thank you, Jeff, for the kind introduction, and thank you to the Federalist Society for inviting me to participate. It's great to share the stage with former colleagues, clients, and worthy adversaries. In the interest of full disclosure, let me mention that I have sought an appointment in the new administration. It appears that the administration is, as they say, pursuing other options, but there you have it. So let me briefly address the lasting positive change aspect of our subject today, or so-called durability. I think we all know that truly lasting change has to come from Congress. But as we also know, that is extremely difficult. And rather than selectively amending our venerable environmental statutes for the 21st century, both parties seem to have a bias toward big, beautiful bills that can eliminate individual roadblocks, but do not result in lasting reform. The Inflation Reduction Act and its provisions regarding the Mountain Valley Pipeline and mineral leasing in the Gulf of Mexico are examples from the Biden administration. I would like to see, and maybe I'm a wide-eyed optimist, but it seems like it should be achievable with some compromise, some modest statutory changes to NEPA. I think much litigation could be avoided if Congress would specify what the agencies need to discuss in terms of climate change. Downstream, upstream, midstream, whatever. Just tell the agencies what they need to do. They can do it and they can be done with it. Next, in terms of durability, is rulemaking. And I think we will see that especially in the NEPA space after the DC Circuit's decision in Marin Audubon Society and the new administration's embrace of that decision in moving NEPA rulemaking away from a centralized model under the Council of Environmental Quality toward the agencies. But in that regard, I'd say let's be patient. Consider the agencies that have neither a deputy secretary nor a chief lawyer. Agriculture, energy, EPA, Interior, all my former clients. And although transportation has a deputy secretary, it doesn't even have a nominee for general counsel. So I would say on the rulemaking front, be patient, it's coming, and we'll do our best to give Sam and his colleagues some work to do. So with that, I will end and turn it back to my fellow panelists.
Great. Thanks everyone for those opening remarks. We've actually kind of used up our allotted time for the intro. I was going to give 1 or 2 minutes for rebuttal, but I think I'll just jump into federalism and you can use some of that time if you want to respond to anything that was said during the opening. In the environmental law realm, we often see federalism in the sense that federal and state agencies work cooperatively together to achieve shared environmental goals. In some environmental laws, states have primary regulatory responsibility with the federal government in an oversight role to ensure minimum standards are met. One might say that recent proposals have advanced federalism by elevating the role of states in environmental programs, but others might say that federalism principles have been diminished by proposals to, for example, scale back Section 401 of the Clean Water Act or with regard to the California situation. So let me ask our panelists, and Sam, I'll begin with you on this one. How do you see the new administration's approach to federalism in the environmental law context? What concerns you most about what you see regarding these federalism principles?
Well, I don't see a consistent application of federalism principles. That's I guess the simplest way to say it. And a good example is there was a recent EO on April 8th about protecting American energy from, quote, state overreach. And it was very explicitly targeted at states that had policies, internal state policies that the president believes are inconsistent with his overall energy agenda. And the president is laying out an agenda saying if you as a state have policy objectives that are inconsistent with federal policy objectives, we're going to punish you for it. And I think I don't use the word punish lightly. It really is punishment, right down to statements about you only get disaster relief if you toe the line on other things. These violate basic things that the Supreme Court has said about overreach, not to mention broader ideals of federalism that I think conservatives hold. I'll leave it at that.
Okay. Thanks, Sam. Professor Mergen, did you have anything else to add there?
I guess what I would sort of say is that, the federalism, I think, and you had sent us some helpful notes, Jeff, and you had sort of raised the issue of red and blue federalism. And I think, before this audience of Federalist Society, where we are concerned with the rule of law issues, and it's really important that we be consistent about application of federalism, that we not pick winners and losers. And I think that, historically, the Justice Department has tried to do a pretty good job on these issues. I'll give you one example. The pork producers case that went to the Supreme Court, the preemption case out of California that went to the Supreme Court during the Biden administration. The Biden administration made environmentalists very unhappy with its position in that case. It sided with the pork producers. It sided against California. And it did that because it felt, I think, that was sort of what rule of law principles required. And the government was wrong, right? The Solicitor General lost that case, and the Supreme Court sided with California and against the industry there. And I think, these are issues that really demand adherence to principle, right? We really need to be thoughtful about this. And if we fall back on sort of a red and blue federalism, which I think that the Trump administration often sort of promotes, right? We like our side and not the other side, and federalism for us and no federalism for you. And I think, all of us as lawyers, we need to think about adhering to sort of a set of principles that'll guide us as we navigate this important concept to our framing and founding. And I'll stop there.
Great. Matt or Eric, how do you see federalism principles advancing in these early actions and proposals by the new administration? And Matt, I'll start with you.
Great. So yeah, let me touch on one thing that was mentioned in the openings, which is the push for electric vehicles. And that actually touches potentially on federalism as well, given that the state of California has, and certainly an outside impact on the EV industry in our country. And right now, pending before the Congress is a proposal to rescind the California waiver, as it's called, which allows California to set emission standards. And just today, actually, talking about what's good for the auto industry and for consumers, the Alliance for Automotive Innovation, which is the leading trade association for vehicle manufacturers, put out a statement that says that the aggressive regulatory push towards battery electric vehicles ahead of consumer demand and without market readiness will reduce U.S. vehicle production and auto jobs versus a more balanced approach that prioritizes and preserves vehicle choice. So while EVs are out there and a lot of consumers are buying them, I think that's a huge signal that what happened in the last administration was using or weaponizing the law, and in this case, the California waiver, to push too far, too fast beyond what the American economy was ready to accept, instead of just letting normal market forces compete. I'll say that also for renewables, what the Inflation Reduction Act spent, billions of dollars trying to promote and prop up renewables and reduce GHG. That's not a free and fair market competition approach where renewables are competing against fossil fuels. It was propping up the industry. I don't think anyone's opposed to letting various forms of energy compete and let the best form of energy prevail. With respect to federalism, I'll make one more point. I also noted the president's executive order on states potentially having laws that prejudice other state industries. It's not. I don't think that executive order was based on a state wanting a policy, but it is states who are passing laws like the climate superfund laws in Vermont or New York, who are attempting to regulate beyond their borders. That's a whole nother animal than simply regulating within a state. Like Professor Mergen pointed out, the pork industry case and the Dormant Commerce Clause issue there. We're talking about states who are passing superfund laws that would essentially penalize lawful conduct that occurred in other states for decades, and even and exempting the combustion of fossil fuels in their own state. And they're not going after their own industries and fossil fuel combustion and use of these products by their own state, the citizens of their states. So I think rebalancing that, returning to a constitutional understanding of what states can and cannot do is very important in that respect.
Thanks, Matt. Eric, did you want to add anything to that?
I don't, Jeff, if you want to go on to another topic.
Well, let me just pause there and see. I mean, Professor Mergen or Sam, do you have any thoughts or responses to this point about states overreaching themselves in the environmental context, and what should be done about that?
I mean, I would just sort of say that this issue, right, of federalism goes above and beyond environmental concerns. It touches on other matters as well, including reproductive freedoms. And I take Matt to say that states should stay in their lane, and that is a viewpoint. And I guess my thought is that would need to be meaningful as a rule of law principle. It would be required to be applied consistently across the board. And I think that's the challenge, because uh, some lawyers are politicians, and politicians like results and not process. Lawyers like process and principles. And that's the challenge going forward for any of these issues. And I also say that I think this is going to be obvious to the very sophisticated audience that we have here, but sort of what happens down the line on sort of the endangerment finding and on things like that may very well empower states in other ways, right? We've seen this funny thing where fossil fuels producers have long argued that there's no role for the states, that the field is entirely occupied by federal law. If the administration starts chipping away at the sort of what federal law encompasses, you may see more complicated questions about sort of common law and the role of the states coming to the fore. And I'll stop there. Sorry, Jeff.
Yeah, Sam, do you have anything else?
Just a quick thought. I mean, Matt raised a lot of legitimate concerns about California's EV policy, but sort of the essence of federalism is that the federal government doesn't get to decide what happens in states, that states have their own areas of regulatory authority. And I think saying California's policy is bad is different than saying California's policy is somehow incorrect. And going after it simply because you don't like the policy is the opposite of federalism. Federalism, requires you to leave the states alone unless there's a principle that says you need to go in the other direction.
Matt, is the concern there, though, that California is exceeding what the Clean Air Act envisioned originally for its role?
Well, just for the audience who aren't familiar, I mean, the law, the Clean Air Act says the federal government sets all tailpipe emission standards unless under unique circumstances, California can demonstrate it, and for historic reasons, which I won't get into, they have an ability to set it. But about a third of the states, known as 177 states under the Clean Air Act, adopt California standards. So we're talking about a third of the country here. But more, maybe back to Eric's initial point, with the Congressional Review Act that's moving through the House of Representatives right now, we may actually see Congress stepping into the role that we all want them to play and resetting what has been an issue that's left to the administrative process. So, I'm certainly for Congress setting national policy in that respect.
Let's turn to the Supreme Court. We've already heard mention the endangerment finding reconsideration, an issue that may very well find its way up there at the highest court in the future. And a lot of issues that the new administration seems to be tackling are on a path to ensuring review at some point or another by the courts. We expect the Supreme Court to rule soon on cases involving citizen suits, climate change considerations in energy projects, and the like. So let's just go down the line here of our participants and ask each of you to share one or two observations about the Supreme Court and how it might be involved one way or the other in questions arising in this environmental law arena during this new Trump administration. And Professor Mergen, I'll start with you on this one.
Okay, great. I'd just like to make a couple of quick observations. I think, and none of us really know what to expect out of the Supreme Court at this particular moment. A year ago, when we were coming down towards the end of the term and we got these sort of landmark administrative law cases, I would have agreed with Matt's point that the Roberts Court is on a sort of deregulatory, anti-administrative straight role. I think if you look at where things are headed right now, we are shifting into an area where it's very hard to predict how the court is going to come out in a lot of these cases. I think the environmental side, my side, we recently lost in the city of San Francisco case, the Clean Water Act case. That case was decided pretty narrowly overall and sort of, in my opinion, oddly on sort of textual terms. It's a 5-4 decision. We're not seeing a sort of a conservative supermajority. That was also true of the Good Neighbor a shadow docket case, Ohio versus EPA. So Justice Barrett has indicated some concern about some of the positions that have been taken in the environmental cases. And I think also that the administration, through its litigation, even as we're just here at the 100-day mark, has really squandered sort of what is key to all of us in our time as government lawyers, which is a presumption of regularity, the notion that the government proceeds in good faith, in regular order, does not offer pretext, but is focused on advancing principles. And I think what we are seeing in a lot of the litigation surrounding the Trump administration's moves are calling into considerable question the government's good faith, presumption of regularity, all of those principles that give the government and the executive branch wins. We all know this because everyone on this panel was a government lawyer at one point or another. And we know how much we leaned into the fact that the government proceeds in regular order. And I think that the court, we're seeing the court push back. We're seeing Judge Wilkinson in the Fourth Circuit push back on some of what the administration is doing. And that, I think, is going to have big consequences for how environmental law unfolds in this administration before the court going forward. And I'll stop there.
Yeah. Eric, you clerk for Justice Thomas. How do you see, and you've been involved in a lot of cases that have made it up to the Supreme Court in the environmental law realm. How do you see this playing out there and the court responding?
Well, I think we're all waiting for 7-county infrastructure coalition for the Supreme Court to weigh in on NEPA. And but by all accounts, we're going to get what I call a dial turning decision. I'm not sure enduring principles are going to come out of that, but I think we're going to get a decision from the Supreme Court that says, as to NEPA, less. And that, I think, will give some tailwind to the rulemaking that I described earlier in the NEPA space, that the Supreme Court will signal to the administration and to the lower courts that reasonableness is the touchstone of NEPA, and rulemaking efforts to go in that direction will be looked on favorably.
Okay, thanks. Sam, how about you? You want to follow up on Professor
Sure.
Mergen's comments and add any flavor?
Well, I agree with Eric that, that the court didn't take 7 counties in order to expand the scale expand the scale of NEPA. I do think it's strange that they didn't dig the case, given all of the stuff that we've got going on in the regulatory scheme. But a broader observation to build on what Andy talked about was that I think this administration is not proceeding in a way that will help it achieve lasting doctrinal change in the Supreme Court. It's swinging for the fences with every legal argument and eroding credibility. If it goes on this pace, I'm not sure what'll be left by the time the October term begins. And that means that instead of like having a progression in NEPA case law that leads to something like a dial turning, the courts, the administration saying, look, we're going to do all NEPA review in 10 days. When you do that, the courts are just going to bat you right back over and over and over again, and it's going to make the administration look bad. And that's not going to help, I think, the regulated industries that want to see change in this area. So writ large, when you see the Supreme Court, I think the Supreme Court's going to be saying, now we're confronted with this extraordinarily extreme administration that we're going to have to push back on over and over, and advocates who we can't trust and who don't necessarily represent the facts accurately. If you're a regulated industry and the government is representing your position in front of this Supreme Court, I think you kind of might wish that this government would step back and that you would do the work and not them.
Okay, Matt, what are your thoughts on the Supreme Court and where things are headed?
Sure. Maybe a couple thoughts. I don't have a crystal ball either about where the court is going, but there are a couple cases I'm certainly watching that could add to the list of the court's course correction, I would call it, on the administrative state. And that's, one, the Federal Communications Commission v. Consumers Research, which deals with the question of the non-delegation doctrine that was argued on March 26th. I'll leave it to the others, maybe more qualified than me, to opine on how that might come out. But certainly, if the court gives new direction on non-delegation and how federal agencies and Congress Congress has to delegate to federal agencies, that could be very big. The other one I think the Trump administration is winning on is the attempt to overturn Humphrey's executor, and then in the case Trump v. Wilcox, I think that's teed up, and I really see this court questioning the long-held position that there is such a thing as an independent agency outside the scope of the president's authority. And so that, part of the flurry of decisions has been, firing some positions that Congress and law, for example, the inspectors general had put conditions on the president's authority to fire. And I think that was all intentional, right? It was characterized in the press as rash or illegal or not rule of law, but the guiding principle was the separation of powers there. And I see that as being one that's going to get traction with the high court.
Yeah, it's sort of related to the Supreme Court and this discussion around DOGE and efforts to reform the administrative state. There's been a conversation around whether Loper-Bright helps or hinders the efforts of a new administration, and certainly one that's geared towards reforming the administrative state, whether it actually helps or hinders those efforts. Any thoughts by any of the panelists on what the Supreme Court was doing there in Loper-Bright and how it plays out in this early stage efforts by the Trump administration to change course? And maybe with that, I'll start with you, Eric.
Well, I think Loper-Bright essentially says you can and should go back to the drawing board, go to the statute, and as anyone who's litigated a NEPA case knows, that's sort of a difficult issue there because the statute is so sparse. I guess I see Loper-Bright in terms of rulemaking as, again, giving a tailwind, giving justification for taking new looks at things and going in with a in a sense de novo approach, and asking lower courts legitimately to put aside some of the older precedent and look at things anew. So again, I think tailwind is the metaphor in this space.
Professor Mergen, do you see it that way? I mean, I guess one other way to look at it is that by sort of removing the opportunity to use policy factors to inform an interpretation, you might reduce the flexibility of a new administration to go a different direction. But what are your thoughts on that?
Yeah, no, I think that's a really good observation, Jeff. I was just going to say that there are going to be times, I think, when I was working with in the Trump 1 administration, it's not as if that there was a categorical rule against leaning into Chevron deference, even though I knew that everyone I worked with didn't really approve of the doctrine, because there were times where you wanted to win, right, and advance your position, and you were going to use the tools in the toolkit. And I think that there are going to be occasions when the administration misses having Chevron deference to lean into. I don't know how many occasions there are going to be, because I'm a little bit more skeptical than Eric that this administration is committed to the kind of notice and comment rulemaking that we have come to expect from the executive branch. And there are many reasons to criticize notice and comment rulemaking. It tends to favor some parties over others. It's very cumbersome, extremely cumbersome, but there's something inherently democratic about that process as well, because people come in, they're able to state their positions, there's a docket that you can track everything. And I just don't know that the administration has either the patience or the personnel to do this. And we have a question in the chat about the April 9th memo going to using IFR, I'm very concerned about just the administration's commitment to fundamental administrative law principles in the first instance. And if they don't have that commitment, I don't know how often Loper-Bright is going to come up. One last thing about Loper-Bright, I still don't think we know what it means. I think it is an extremely difficult decision to parse out. I think most of us sort of in the academic world see three buckets of things identified in the opinion to which some sort of deference is still going to apply. I mean, Justice Kavanaugh wrote a very, I think, nice take on statutory interpretation of the Harvard Law Review some years ago, and he sort of said, like, there are things that are deference-like, right? And Congress sometimes says, define these terms. So, what Loper-Bright, if we had a normal administration, we would all be talking about, we would be settling out what Loper-Bright means. But because nothing is normal about the first 100 days, we are not in a position to really talk about it. But I will say that the administration's Sweet Home missive, I think, misses the boat. That was easily low-hanging fruit. This is the ESA decision decided on Chevron Step 2 about the definition of harm. And the administration has said, well, we're going to go back and we like the Scalia dissent better. But the Scalia dissent has a certain tossed-off quality to it because he's a judge. He's not engaged in rulemaking. He says something about 1,000 years of history, and he says something about the structure of the act, and he says something about all of these words mean the same thing. And the administration just sort of says, yeah, he was right. And it's not the kind of like considered robust analysis you might be looking for if you're going to demonstrate to the courts that there's only one true meaning of harm. And I'll stop there.
Yeah. Matt, did you have any thoughts on the Loper-Bright question?
Sure, lots, but given our limited time here, I'll just make a quick point. When I became general counsel of EPA, a lot of people told me, you may not have liked Chevron, but now it's going to be your best friend. I totally appreciate that perspective in terms of, a thumb on the scale for the federal government. But, I think we've progressed beyond that. And we're now at a point where, a lot of folks probably in this audience believe the deference is not owed or due to the federal agencies in some degree because it's been misused over the years. And so, but there are certain deference doctrines that survive, like on questions of science, for example. The DC Circuit precedent is very clear there. That scientific records get more deference than an agency's interpretation of a statute.
Sam, I wanted to give you a chance also to comment on Loper-Bright if you had anything else to add.
Yeah, I would just say that we environmentalists lose as often as they win on Loper-Bright issues. So it's hardly, there was a lot of debate in the environmental community about where we felt on that, about where we stood on that. And in general, we support the idea of deference because we believe in the expertise of agencies and the ability to sort of interpret broadly worded laws. However, again, this is an instance in which the administration's fairly lawless tactics, I think, are going to work against it. Because if I read Loper-Bright as saying, we think there's a more textualist approach to doing these laws. And when the administration says, look, we're going to use this for all it's worth to cut down laws we don't like, that means that we, as enviros, are likely to be in court challenging the most egregious over-interpretations in the other direction that the Trump administration is advancing. And that's likely to result in not the results that I think a lot of conservatives had hoped to get, which is to cut backs on these laws. In fact, it's going to cement another kind of interpretation. It's just an example of where there's a thoughtful conservative approach that this administration could be pursuing, but they don't have the personnel, the discipline, or the smarts to actually execute on it. What we're going to get is random motion in favor of fossil fuel companies.
So we've received a question that ties back, I think, to the title of the program, as well as our opening comments around DOGE and government reorganization. One of the questions ties to changes in personnel within the agencies, reassignment of personnel, and in particular, the Environment Division at DOJ, whether some of those may be counterproductive. Eric, I might turn to you on this topic first. is the DOGE and related reorganization efforts, in some areas at least, causing potential harm to the agenda that the administration is seeking to accomplish on reforming the administrative state, promoting U.S. Energy production, and the like? I mean, you worked inside the government, you worked inside DOJ, you led teams of government attorneys that handled these kinds of cases. And do you see a tension between some of these efficiency goals? And again, we've, government debt of $37 trillion, no one doubts there needs to be cut somewhere. But do you see tension with those goals and winning cases involving big energy regulatory matters or energy production?
My working assumption at ENRD was that virtually every project, and certainly what you called big projects and permits, Jeff, would be challenged in court by Sam and his colleagues. And those lawsuits must be defended, first usually in the district court, and then in the courts of appeals, and sometimes even in the Supreme Court. And that defense requires lawyers, good and hardworking lawyers. And so I think the long-term goals of the administration are going to be served by having those good and hardworking lawyers, career lawyers, supervised by political appointees. And I hope and expect that the division, the department, and the entire administration will realize that undeniable fact and act accordingly. The appellate section, when I was supervising it, had between 30 and 35 lawyers. That's we're not going to get our $37 trillion back from eliminating. I mean, even if there were no appellate lawyers in ENRD. So I think just pure self-interest ought to engender the administration and its, I think, otherwise admirable efforts to think critically and strategically, and I expect that will be done.
Yeah, Sam, you had commented earlier, I think, that maybe you and some of your colleagues might salivate over the changes because of the potential litigation advantage or other reasons. But do you see advantages accruing to those challenging this administration's actions by the reorganization efforts that are underway?
Well, it may be good in a narrow sense. It's a tragedy in any real sense. Eric knows Jen Newman, who was the section chief at the appellate section until recently, who served all kinds of administrations ably and well, and on day one was sent to the Sanctuary Cities Division of the Justice Department with no explanation and no real, no real stated goal of this. It's so any advantage we get by the drain of talented lawyers is more and tremendously offset by the national tragedy of destroying the civil service, and particularly the Environment Division of the Justice Department. I think everybody here knows that, whether or not we're willing to say it. It's a national crime. And these are people who are by and large, not even by and large, nearly everyone I know is a very talented, high quality servant. They're running for the hills because of the lawless behavior of this administration.
Matt, do you have a thought or two to add there?
When I was general counsel of EPA, we increased our resources, in certain respects, certainly on defensibility. And I thought lawyers to defend the administration's policies while I was there was really important. I agree that we'll need, this administration will need lots of good lawyers to help write rulemaking records, help defend cases in court. It's a feature of our system. So for better or for worse, lawyers are needed for all these tasks, right? So they play an important role.
Well, we're, I think, just about out of time. And so I want to take a moment and just thank all of our panelists for your contributions to this discussion. It's been a very active and comprehensive discussion. And we weren't able to get to all the questions, but I think most of the discussion here covered the things that were asked in the chat. I know each of these panelists would welcome any input or feedback from those who attended. And with that, I'll turn it over to Edie.
Yeah, on behalf of the Federalist Society, thank you so much to Eric, Matt, Professor Mergen, and Sam for your excellent discussion today, and to Jeff for moderating. We're so grateful for your time and expertise. Thank you also to our audience for joining us. We really appreciate your participation. We hope to see many of you at the Executive Branch Review Conference next Wednesday on May 7th at the Mayflower Hotel in Washington, D.C. Registration can be found on our website and will close on Monday. You can also stay up to date with other announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.